Good afternoon, everyone. Thank you for joining us today for this Philanthropy Roundtable webinar. I'm Debbie Gatte. I'm Vice President of Strategy and Programs, and it's my pleasure to welcome you today. Our conversation today is going to be about what about the kids, advances in protecting the rights of children. And this is a topic I have really been looking forward to sharing with all of you. There's been a lot of news on these fronts. But first, why would the Roundtable host this conversation? For the Roundtable, our programmatic work has three important themes: America's founding principles, pathways to opportunity, and strong communities. And when we think about what it takes to help children succeed, all children succeed, it really requires a combination of these things, as we are going to hear more about today. So, some context setting. There are about 440,000 children in the child welfare system, and I hope that number is a good estimate. Here's a number that really surprised me. About 18,000 go missing in a year. 18,000 foster children go missing in a year. There were also 48,000 children involved in the juvenile justice system. It's quite a few. That's in 2019. And approximately 500 of those children were under the age of 13, right? So for those of us who really do care about what is going to happen to the next generation, the juvenile justice system and the child welfare system are very, very important for us to understand. They both deal with one very vulnerable population, and kids are actually circulating and cycling between different government agencies, sometimes living in facilities. So my question is, are the rights of these kids protected in these systems? Are we living up to our view that children are precious and that every child has the potential to flourish? Do our systems match those sentiments? And what are we doing about it if not? I'm really excited to welcome three experts who really are doing something about it. And there is going to be a lot for us to talk about. So I have with me today Tim Keller, Senior Vice President and Legal Director at Gen Justice, Jake Horowitz, Director of Public Safety Performance Project at the Pew Charitable Trust, and Frank Cervone, who's the Executive Director of Support Center for Child Advocates. What we're going to do today is have a conversation one-on-one with each of our guests, and then bring them all together so that we can have a conversation together and take your questions. So please do feel free to drop your questions in the Q&A box as we go along. And we'll be looking for those. Sometimes we might answer it during the conversation. Sometimes we might take it in the Q&A. But either way, we're going to try and get as many of your questions in as possible. So Tim, why don't you join me on the virtual stage so that we can get started. Hi, Tim. Welcome.
Hi. Well, thank you for having me.
Yeah. So Tim, you recently joined Gen Justice after a very successful litigation career at the Institute for Justice. And that was in school choice, right? But what does Gen Justice do? Because it's a relatively new organization. What does it do?
Yeah, we're about 3 years old, and Gen Justice works in legislatures and courtrooms to mend the broken child welfare system. We want abused and abandoned children to have families that they desperately need, and we want them to have the justice that they deserve. And so we do this by working on what we call 3 levels. This is the micro, the macro, and the super macro. And so at the micro level, we help individual children in their court cases day in and day out through our pro bono children's law clinic. We provide emergency legal assistance and counsel to children, foster families, kinship placements, whenever we feel like there is nobody in court speaking up and advocating for the rights and interests of the children in their own cases. And then at our macro level, we're changing laws to change lives. We work in our home state of Arizona to implement nonpartisan reforms and then share our work nationwide, helping local communities tailor reforms to their needs. And since 2017, when Gen Justice launched, we've worked with local leaders, national partners, to drive the adoption of state and federal policies that have impacted literally hundreds of thousands of kids. And these measures have expedited the search for relatives, shortened the time to adoption, and improved legal representation for abandoned, abused, and trafficked kids. And then finally, the super macro. That's where we seek to enforce constitutional rights. We believe that children are entitled to due process and equal protection. We also believe that every child deserves a family. And so our public interest legal work at that super macro level seeks to vindicate the constitutional interests of children to be free from severe abuse, and when abandoned to the state, to be adopted in a timely manner.
So that was a lot, because there were a lot of issues in there around due process and constitutional rights. I want to break it down just a little bit, because it may be a surprise to some people. It was to me. And I actually think it was Frank Cervone, who we're going to hear from later, that kind of opened my eyes around this. Some may be surprised to hear that kids in the child welfare system don't have a guaranteed protected right to legal counsel, even if family members do or others do, right? And when we think about our criminal justice system and how every defendant has right to counsel, and there isn't an equivalent protection for children in our child welfare system in every state, that's surprising, right? So how can that be? And what can we do about it? I know you just mentioned doing something in Arizona. So how can that be, and what can we do about it?
Yeah, well, you're right. I mean, the fundamental rights of children are at stake in these abuse and neglect proceedings in court. The state has the power to remove children from their homes. The court has the power to determine who they live with, for how long, how often they get to see and visit with their biological families, and ultimately has that radical power to sever the parent-child relationship. And yet most foster children throughout the country, they do not have a lawyer advocating for them in their cases. And I tell you, we talk to so many foster families, kinship placements through our children's law clinic, and it is so common to hear them tell us when we pick up that phone to say, I feel like there's nobody advocating for the child in my home. And so we have sought to change that out here in Arizona. So the efforts out here in Arizona actually in many ways began in 2019. When my colleague Darcy Olson got a call from the White House and said, what are some ideas for making some really important reforms in this area? And one of the things that happened at the federal level was a change to the law that would allow states to be reimbursed for the cost of providing high quality child representation, lawyers for kids. And that change laid the groundwork for a bill, our signature bill that was drafted by my wonderful colleague, Rebecca Masterson, that provides a lawyer for every child in Arizona who is entering the foster care system. That law was signed this year by Governor Doug Ducey, and we're really excited to see it implemented. We're excited to be involved in the process of training the lawyers that are going to be appointed to serve these kids to ensure that they've got the highest quality legal representation as possible, and that they'll finally have a voice in court speaking for them, filing motions on their behalf, trying to get them the services they need, trying to push their parents to engage in the services that they need so that families can be reunited, shortening the time in care. There have been several studies of states and localities that do provide representation for children, and we know that children with lawyers tend to visit their family much more often while they're out of home care, that they exit the system 2.5 times faster than kids without legal representation, either being reunited with their biological families or having those rights severed and move on to adoption. And the last thing is that children with lawyers tend to be adopted more frequently if they can't return safely home.
So it's really important for people to understand this right to counsel isn't just about the initial stages of separating a child from their family. It has consequences for how that child will do post being in the system. And I think that's really important for people to know. So what are the other types of due process types of rights that you're working to protect? Because, if I was mentioning to my neighbor yesterday, there isn't even a requirement for them to seek out relatives within X amount of days, right? So what are the other kinds of things like that are in the system that you think we need to change?
Well, so, you just mentioned helping find relatives in a timely manner. So one of our signature legislative reforms that we've pushed here in Arizona and that has now been adopted in Georgia and Louisiana is what we call the Family Search and Stability Act, which really has two goals. Number one is to ensure that children who are placed in care are placed with relatives as soon as possible. And in fact, there is a federal law, federal requirement that state agencies seek out these relatives within 30 days of a child coming into care and to contact them and see if they're willing to take them as placement. But the reality is that requirement is so often ignored all across the country. And so our reform requires that agencies file with the court documentation of their efforts to seek out and find these relative placements as quickly as possible so that the judge and that the other parties can hold state agencies accountable for conducting that relative search. Because what happens so often that we see time and time again is that if that relative search isn't conducted, a child will be in care for a long period of time. Ultimately, if they can't return home, rights are severed. And then all of a sudden, a relative comes out of the woodwork that the child has no relationship with. And the courts and the relatives want to remove the child from a loving home where they've grown up. Maybe it's the only real parents they've ever known, and they want to disrupt that relationship. And so that's the second part of the Relative Search Act, is that we put in the law a presumption that the foster family is essentially kinship after 6 months with the foster family, so that if a family does come out of the woodwork after a diligent search, the court does not have to remove the child. And if the court determines it's in the best interest to stay with their foster family and ultimately be adopted by the foster family, the court can make that decision for the child's best interest. So we've got those twin goals of limiting the time, limiting the number of times kids are moved from place to place, as well as ensuring that they can be with families as quickly as possible if there is that loving, caring relative available to take them in.
And this is what it looks like if we are truly thinking about the best interests of the child, right? Which is a phrase that gets used so much in these conversations. So how can we go from making these statutory protections where state by state by state, how can this be at the same level of other constitutionally guaranteed rights that Americans have?
Yeah, well, you're so right to ask that question, because statutory changes is just one part of the equation. Ultimately, we're going to have to see courts recognize these kids are protected by the Constitution. They have constitutional interests and constitutional rights at stake in their cases. So eventually, I believe the U.S. Supreme Court is going to have to weigh in here. In fact, the court has an opportunity to recognize that kids have important rights and interests at stake this term. There's a case involving the city of Philadelphia's decision to terminate its relationship with Catholic Charities because the agency will not license LGBTQ individuals or couples as foster parents. And Jen Justice filed an amicus brief in that case, pointing out that there was a lot of argument going on in that case about the adults, but the children's interests were really being ignored. And so we urge the court to recognize that the 14th Amendment secures a child's interest in finding and forming families. And as a consequence, if the court were to recognize that, the consequence would be that the state would bear a heavy burden to justify any restrictions that were going to be placed on children's access to foster or adoptive parents. The reality is that any government action that reduces the availability of quality foster parents and families has dire consequences for these kids. Just too many American children are suffering as a result of not having adequate access to loving potential adoptive families. And so the court has an opportunity this term to recognize that the children's rights are at stake in these types of cases. And we'll see if they take that opportunity in just a matter of weeks. It's one of the handful of remaining decisions left to be handed down.
Wow, they must be thinking about it hard. So we'll come back to that, because I am wondering, if that case goes a certain way, whether it makes the right to counsel issue a lot easier too. So it's probably a sequencing here, but we'll come back to that, Tim. Thank you so much for sharing the work that Jen Justice is doing. We'll have you back in a few minutes. We'll have you go off camera, and we'll have Jake Horowitz join us. Jake from Pew Charitable Trust. Hi, Jake.
Hey, Debbie. Good to see you.
Good to see you too. So you and I have been talking about juvenile justice for a while, and you actually are someone who's taught me a lot about what's going on in that space. So thank you for being here today. And I know that Pew has been invited to work in partnership with state officials in a number of different places on juvenile justice reform, right? So In which states are you actively working, and what problems are these state officials trying to solve that they've invited you in?
We've worked with about a dozen states over the past decade. We're currently engaged in Pennsylvania and Maryland and Oklahoma, Idaho. And just over the years, right, it's been everything from sort of the supermajority conservative Republican states like South Dakota to the true blue states like Hawaii. I think showing this is a bipartisan issue. I think, before getting to the problem statement, the good news is that states have made a lot of progress in this area. So we're at generational lows right now in terms of juvenile crime. And since the turn of the century, there's been a substantial reduction in juvenile incarceration. And so, I think it's important context. That said, a bunch of states are still coming to this issue. And while every state's different and they have their own sort of problem statements, the common denominators tend to be around a few issues. First, that lots of kids are still being separated from their families and put into state custody, oftentimes for relatively low-level offenses. These residential facilities that they're being placed into are very expensive and ultimately produce unsatisfactory results, which can range from unsafe conditions to just very high recidivism rates. And so, a quick illustration of that is that this week, actually, Michigan announced that the state was going to be looking into some juvenile justice reforms. And this falls on the heels of two rather explosive stories covered in the media over the past year. The first was a young girl removed from her home and incarcerated for failing to do her homework, which the judge considered a violation of probation. And the other, which happened within a month of that, was a child being killed during a restraint, allegedly for throwing a sandwich. And so these are extreme examples, but they point to these underlying problems within the system.
Wow, I'm still processing those two examples. All right, well, so clearly there are some problems, but that is good news that the overall numbers are coming down. Clearly some problems. So generally, the work that you've been doing in these states has been done through task forces. And how do those work? What is a task force? How does it work? Who's invited to join the process? And what role does the data play? Because I know that data is actually really important in the work you do. So tell me about the task forces and how you work through that.
Yeah, sure thing. So the model we've found to be quite effective is to have state leadership, and we're talking at the level of governors, chief justices, legislative leadership, charge a task force with studying this issue and coming up with consensus recommendations to fix the problems. The goals of this work, again, vary somewhat from state to state, but it's all about protecting public safety. It's about ensuring some measure of accountability. It's about containing or reducing correctional populations and costs, and finally getting better results for children and their families. The task forces themselves, I describe them almost like the Noah's Ark of juvenile justice policymaking. So you might have, two legislators from the House and two from the Senate. You might have two juvenile judges. You might have two kids involved in the system. You might have a child welfare representative, a representative from the education system, and so on. The point, though, to all that is to make sure that the policy options are considered and really thoroughly vetted by key stakeholders who can, vouch for the policy recommendations' legitimacy. And finally, to your point about data, it sets the foundation for the work, right? So often in policymaking, people have a solution in mind before they really have a problem well developed. And what data helps to do is get people to a common understanding, a shared understanding of the problem they're trying to fix, and then establish a metric for what success will look like. And, final note on this is I don't want to be naive, right? Data will not resolve all the difference. It will not inoculate against sort of the most cynical parts of politics, but it is sort of a touchstone for many of these state processes.
That's a good acknowledgement at the end. I appreciate that. So what have some of the key findings been in the states, and how have officials, I'm really curious. So what have some of the key findings been, but then how do the officials respond to those key findings? And then do you have examples of actual reforms that took place because of those?
Yeah, I mean, there's so many examples. I'll use one to illustrate, right, what's going on here. So we worked with Kansas back about 5 or 6 years ago. Again, invited into the state, Governor Brownback, the Chief Justice, legislative leadership. This was during a time of real acrimony between the branches of government, if you recall back then. And so this was, it was going to be a tough lift for any policy issue. What they found, though, start with sort of the data, right? They were spending $90,000 per child per year for residential incarceration. The 2/3 of the kids in their non-secure facilities, and 1/3 of their kids in their secure facilities had been placed there for a misdemeanor offense. Right? In the adult system, it's going to take a felony to put you in prison. And so the idea that they were putting children in these facilities, including secure, like these look like jails and prisons for misdemeanor offenses, shocked some of the folks in the system. There were really substantial regional disparities, which are often referred to as justice by geography. There were very substantial racial disparities. For example, Black youth were more than six times as likely to be in the deep end of the system as white kids. And finally, you had judges saying, I have no option locally. I don't think this kid is a public safety threat. I don't want to punish them, but what am I going to do locally? So I have to send them away to that state residential facility that might be several hundred miles and several hours drive away. So, when you get people around the table telling these kinds of stories, and they're saying, well, they're focusing in on that issue. Some of the folks, I think, almost had become a little numbed to these things, became complacent in a way. Others were just surprised they weren't aware of these things, and so that really motivated policy solutions. They were eventually manifest as Senate Bill 367. It passed the Senate unanimously by overwhelming margins in the House. It did, a few basic things. I don't want to get into the policy weeds here. We can do that later if you want, but it substantially limited placement of kids in these residential facilities. It created a fiscal lockbox to capture savings and then reinvest those in programs we know reduced recidivism, and finally establish some oversight mechanisms to track performance, to measure for performance, to hold government accountable. The great news here out of all this is that, just 2-3 years later, Kansas had experienced a 63% reduction in its out-of-home residential population. They've moved $30 million out of what used to be correctional facilities into evidence-based programs in the community, so that every judicial district had access to one of these programs. And so, and by the way, arrests kept falling, right? Arrests fell 29% during this period. So this stuff can all be done safely. We can have less crime. We can have lower levels of correctional control. We can have more and better services available in the community to kids living at home.
That's significant. The 63% is just standing out as one of many significant things, outcomes. So that's a really great example. Congratulations on Pew's role in making that happen in Kansas. So I want to circle back to something that you mentioned as you were describing the Kansas example. And this is the issue of racial disparity in the juvenile justice system, because I do know that this is an issue a lot of people who are working on criminal justice reform care about. Now, you have been working with the data, right? And so I would love to hear from you. What does the data show when it comes to the juvenile justice system, and how are states addressing what that data shows?
Yeah, the most basic fact, as soon as you dig into the data, what you see immediately is that children of color are overrepresented at every stage of juvenile court processing. And their degree of overrepresentation grows as you get deeper into the system, right? From arrest to court case, to adjudication, to placement in state custody, to transfer to the adult system. So those disparities get worse and worse. As an example, when we were working in one state where Black youth were only 1% of the state's residential population, they were 5% of kids brought into the court for misdemeanor offenses. They were 8% of kids put on probation for misdemeanor offenses, and so on and so forth. These are, disproportionately kids from neighborhoods of concentrated disadvantage, from neighborhoods with higher levels of violence, and very high levels of justice system involvement. But that's not to let the juvenile justice system off the hook. We know there are policies, there are practices, there are biases that can create and sustain racial and other disparities. As far as how states are addressing it, there's no one-size-fits-all approach. Some of the common denominators are limiting discretion, so you have less of that variation and justice by geography, heightened scrutiny to this issue, trying to figure out why are racial disparities arising and being sustained. A focus on implementation. A lot of this stuff can be addressed not just through policy, but through how the policies are implemented. And then some real data tracking, right? In the end, what we're trying to get is to a system that greater approximates equity, and you can track that through numbers. So, one example of Kentucky was a process called the FAIR team process, which was a pre-court diversion. And the idea was, before we bring a child into court, let's sort of rally people, circle the wagons. We have social workers, we have the child's parents, we have educators, we have juvenile justice system representatives and say, why is this kid before us today? Not what is the offense? Why are they here? What's happening in their life that we can fix and perhaps fix without any juvenile justice system involvement? And a quick anecdote, I happen to be in Frankfort, Kentucky, when a precursor to these FAIR teams, one of the guys who helped develop this in the state, and he told this story about a kid who had been truant for quite a while. This is sort of late winter, and they sort of rallied to something like this around. And what they find, well, this kid did not have shoes that he could wear through the snow, right? Didn't have, like, this was what was causing the problem. So the solution was not court involvement. The solution was buy the kid a pair of boots. And it's not always that simple, but I think it's this kind of idea where you get people around to solve the problem, not sort of the symptoms.
Yeah. Okay. Well, that's a pretty clear example, Jake. All right. Well, thank you. And I'm going to ask you to step off the virtual stage. I'll see you back here in a minute. And Frank, have you come and join me? Hi, Frank.
Hi.
So I was going to get you to do the duck so we could see the logo behind you, but you are with, well, we see part of it. You're with the support center.
I'm not touching that camera again.
Don't touch it. You're with the support center for child advocates. And unlike, well, it sounds like Gen Justice is representing some kids, but you represent kids in court. You are the legal counsel, and you work with a lot of pro bono attorneys to actually provide that representation. I'm curious what SCCA does, if you could share that with us, but also how many kids are you working with through how many attorneys? And you're based in Philadelphia, so give us that picture.
Now, so Pennsylvania is a state licensed and county run state. So everything is county by county by county. And we represent kids in what's called Philadelphia County, which happens to be a city, obviously one, large, big like Phoenix, big population, the poorest large city in America, sadly enough. And that really speaks to some of the story we're going to talk about today. We represent in the pre-COVID time around 1,100 kids a year. So we're a big litigation shop, a representation shop, but we do child advocacy in a multidisciplinary way. We think that lawyering for children is a multidisciplinary craft. So our model is to team volunteer lawyers from the Philadelphia legal community with staff social workers and staff attorneys. So every kid gets a master's level social worker. So for 1,000 kids, we in fact have 20 master's level social workers. It's a big cadre of social work support. In some conversations, we actually look more like a social service agency because there's so many social workers. But we're not providing social services per se. We're not the child's therapist. We're not the child's a teacher. We're not taking the kids home. We're not their foster parents, except somebody might be on our staff just by way of coincidence. We're the child's lawyer, but we think that lawyering comes in that multidisciplinary fashion. It's really an interesting development in parent representation, which we've mentioned a couple of times. The federal legislation that was mentioned earlier, that Tim mentioned around the funding of representation by the feds, also expanded to eligibility for parent lawyering and for the social services supports that a children's law office might have, a parent's law office might have on board. And so what you're seeing are parent lawyer operations adding social work support and adding peer support specialists, parents who've been involved with the system and can provide a kind of empathy to this parent who is their client. So it's really interesting development on one might say the other side of the aisle of this parent-child representation construct.
Right. Interesting. That is interesting, Frank. I wasn't aware of that second part. So we've been talking about these two systems. We have the child welfare system and we have the juvenile justice system. We've got kids who are involved in both. You would think that these two systems should work together. How often when you are working with these children through SCCA, are they involved in both systems? And what are the major issues that you see as somebody who has to work with both systems? What is the major set of issues that we should care about?
I always like to say when talking about these systems, and particularly for a lay audience that may or may not kind of be aware of the inside baseball rules of our game, the delinquency or juvenile justice system works with kids who have at least allegedly done something, right? They were the actor, one might say. And the child welfare system in Philadelphia, called the dependency system, or the abuse and neglect system in some jurisdictions, for children in need of protection, or PINs, persons in need of protection. These are kids, something happened to them. So in a way, they were victimized, one might say. So you have two different variables there as to who the actor is, but in fact, they're the same kids with the same experiences. So lots of our kids, probably, 5 or 10%, really, just what you're talking in Philadelphia, that's hundreds and hundreds of kids, are simultaneously involved in both systems. Much more typically, they started out in one system, in a way, sadly, graduated into the other system. And I say sadly in particular because we should be talking about graduation from high school. Instead, we're talking about graduating to a more challenging, really sad kind of intervention by government in their lives, namely that a kid, acted out in a manner that would have been a crime were they an adult. That's what gets a kid into the juvenile justice system. We all have to think about why that kid acted out that way. It's a really important key question of why that kid got into this situation.
Okay, that's a very clarifying. Yeah, it's a good way to think about it. Actor, something happened too. Now, when a child is involved with both systems, what do you think are the big issues that we should be aware of? Like, what are the problems? What's wrong?
Yeah, in a way, that question really becomes a microcosm of this, both systems standing on their own. One of the biggest problems is the siloing of resources, of people, of professionals, and of services. So in a child welfare only case in Philadelphia, a kid might have 8 or 10 different professionals involved with their life, right? And that kid is part of a family. So the family's got all those professionals, plus some people who might only be working with the parents. The juvenile justice side is a little leaner because it runs by and large through the construct of the prosecutor's office and then through probation, because probation is going to provide the supervision of services rather than this kind of much more multifaceted child welfare delivery system. Right? When you put those two systems together, you get big tables of people. I mean, we have meetings and we really believe in getting everybody together. One of the ways to break through the silos is to get everybody in the room. It becomes a big table, dozens, sometimes dozens of people. I was on a call today. We've been doing a weekly call about a kid who's not a delinquent kid. There were 15 people on the call from 12 different agencies, right? That's not unusual. It's a little complicated because of his needs, but you see this all the time, and that makes for tremendous inefficiencies. It makes for kind of finger pointing of who did what, the breakdowns of, well, I was waiting for Debbie to send the referral, and Tim didn't follow up with this appointment, and Jake was there on the wrong day, and who's paying for this anyway? Kind of questions, right? And we've not, as a community, really figured out how to simplify services while we have been, in a way, getting more specialized, going in exactly the opposite direction, right? The professionalization of our work has made the table bigger, because if your child has a bunch of issues, you want the expert for each of those issues at the table. That's the way we do it with our kids, but we're running the show, right? You're the case manager for your kid's life. The case manager in the child welfare system is some worker from a children and youth agency. It's the probation officer on delinquency. And then there's this interplay of 2 case managers and a multiplicity of roles and services along the way. It's no wonder we're not really making tremendous progress, except in the juvenile justice area that Jake described, which is, I find fairly remarkable, that the system is actually shrinking. No one ever expected this, and certainly not at a time when we're having such big problems with overcrowding in prisons and a hell of a lot of crime in the world.
Yeah. So Frank, I'm curious, does SCCA get involved in trying to reform the system itself? Or do your volunteer attorneys get involved in trying to do that?
Yeah, a lot of our systemic advocacy comes from staff out. And we try to respond to the problems that arise in our cases and keep it organically connected to the cases and the work. So again, the case just this morning is a kid with on the autism spectrum who's been stuck in a congregate facility for a really long time. And I wouldn't even upset people by saying how long, but an extraordinary length of time. So the individual question is finding a home for that kid. He can't go back to his parents for a bunch of different reasons. And the system has to find an answer, right? A permanency resource for that kid.
Mm-hmm.
And our system is doing a really bad job of developing homes for special needs kids. Today, it's kind of a national crisis, actually, in a lot of ways, as both our friends mentioned. The reduction in use of congregate means we have to use families more, right? Right. The needs of the kids didn't disappear. We're going to respond to them differently. We think in a more enlightened fashion with family, with their own family of origin, their birth family, their relatives, or with stranger families, people who step up, traditionally thought of as foster care, right? There are way fewer foster parents in the game these days than there were, at a time when moms were at home and out of the workforce, when churches were very involved in recruiting foster parents, and when the game wasn't, nearly as challenging.
Yeah. All right. Well, okay. So Frank, thank you very much for sharing your experiences and your thoughts. I want to ask Jake and Tim to join us so that we can have some discussion together and take people's questions. And folks, do drop your questions in the Q&A box so that we can address them. But Frank, there's one question that came in that before we start the bigger conversation, how is SCCA different than like a CASA, for example? That was one of the questions that was asked, and let's address that off the top.
So in right to counsel states, as Tim talked about at the beginning, there are states that have a statutory or perhaps state constitutional, but mostly these are statutory right to counsel. In those states, the lawyer for the kid is a lawyer. CASAs are typically not lawyers. They can be, but they're not playing a lawyer's role. They're playing what we think of in the literature as a friend of the court. So they're advising the court as to the needs of the child. And the way I always remember the touchstone is the state of Washington. It happens to be the home of CASA, right? National CASA is based there. And it was, as I recall anyway, it's the first CASA program. And CASA got created there because there wasn't a statutory right to counsel. In fact, there's still a very limited right to counsel all these years later in the state of Washington, not to call out our friends there, right? But so, well-intentioned lay folks stepped up and said, we want to be the voice of the child in court. And hence the name of the tagline of National CASA, the voice of the child in court. So these are trained lay folk who are providing a best interest analysis, that is what this child needs. They're visiting the home. In Philadelphia, they're supplementing a lot of the private attorney court-appointed cases. So they're doing actually some of the field work in support of the court-appointed lawyer for a kid. Not in our cases, because our social worker lawyer teams are doing the home visits, but in other cases, that's the way it goes.
All right, thanks, Frank. Tim, did you want to add anything to that?
I think Frank did a great job describing it. Like out here in Arizona, not every child in the system will be appointed a court-appointed special advocate. Some of them have one, some of them don't. Some of them are very involved, not just in the court case, but they'll attend meetings at school and advocate for services for the child through an individualized education plan program. I think CASAs can play a really important role in a child's life as when they are in the system. And certainly I hope that, that will have appointed counsel out here in Arizona. That counsel and the CASA will really be able to communicate and work together so that, to the extent the CASA is in that home more often or visiting the child on a more regular basis, that they're communicating what they're seeing with the child's attorney. And certainly I hope the child's attorney is in fact visiting their client, in person, meeting them face to face. But I hope it can be a very cooperative and collaborative working environment. Like Frank said, the work of the child lawyer should be multidisciplinary. They should be communicating with all the members of the team getting data and information from a lot of different sources. So hopefully it'll be a very productive working relationship with CASAs and child lawyers.
Very interesting. And then balancing that with the image of 15 people sitting around the table, right? So, all right, okay. So question for all three of you, and Jake, I'm going to start with you on this one. So obviously at the Philanthropy Roundtable, we work with philanthropists, and these are people who are committed to ensuring that every child has best pathways to opportunity, right? So I want to ask, what can philanthropy do to help? Because these are two government-run systems, and they necessarily involve government, right? So what can funders do to help?
Well, the good thing is there's no shortage of opportunity. From a philanthropic perspective, I'd sort of divide it into 4 buckets. The first is direct service, right? A lot of philanthropists fund locally, fund programs, and a lot of these can be alternatives to system involvement. The second would be data and research, going back to what we talked about earlier, right? Work to help clarify and identify problems, work to help evaluate proposed solutions to find out what really works. The third would be, and very dear to my heart, is consultation to state governments, local governments, federal government, right? These folks all have day jobs. This can be our day job. We can help them get through very tough policy discussions and move solutions forward. And the fourth bucket would be advocacy. Issues compete for oxygen in state capitals and on county commissions, and advocacy can help place issues on the radar and sustain them there.
Okay, thank you. Thanks, Jake. Tim?
There we go. Got myself unmuted.
We always have to have a "you're muted," right?
No, I know. I didn't want to start speaking until I got that button clicked. So, philanthropy does a really terrific job of meeting many of the basic needs of kids in foster care, from beds to backpacks, from first aid kits to clothing, and obviously we want to continue to see those daily needs being met. It means so much to the kids in care, but I do think that philanthropy can play an even bigger role in helping organizations push, really systematic, truly transformative efforts to make and improve the lives of kids, both in the foster care system and in the delinquency system as well. And so really finding those partner organizations that are doing the frontline work to push forward reforms that are going to reduce kids' time in care, ensure that their voices are adequately heard in court, find those 18,000 missing kids, Debbie, that you mentioned, many of whom don't even have a picture that can be shared with law enforcement agencies. Some of these reforms, can really truly radically and literally life-saving without a lot of effort. We just passed a bill out here in Arizona to ensure that every child in care has a picture available that can be shared with law enforcement as soon as they go missing. And so, really finding out those organizations, seeking them out, like the everybody here, and working with them to really transform and change the system.
All right, thank you, Tim. And Frank, what can we do?
I always like to think that quality matters.
Mm-hmm.
Quality is kind of expensive. When we represent a kid, it costs us about 3 times what the city of Philadelphia is willing and able to pay us. So we can, and this is very typical around the country, most organizations who are going to represent kids, who are going to represent parents in this business, are not going to be able to do a ton of fundraising. They might do a little bit of fundraising. So mostly they're going to deliver the service at the level of caseload, staffing, time, right? These are all the kind of metrics that one might convert dollars into, right? That's what it looks like inside an agency. They're going to deliver that service at the level government is able to pay for, right? Hospitals are going to do the same thing, right? They're going to generate a little charitable dollars, but only the biggest and best of them will say, this is our standard of care. If government's going to pay down here, we're going to bring it up with charitable dollars. So I invite funders to think about paying for quality. The second is to pay for the direct service that Jake mentioned. In my experience, sadly, lots of funders, probably none that are part of your enlightened group, Debbie, kind of want to change the world with their $1,000. We write a lot of proposals in a year. We do a lot of foundation work, right? And you see it, and every $1,000 matters to us. But what new program are you going to deliver for the $5,000 grant we're delivering? Well, $5,000 for a new program. I mean, it'll pay for about a week and a half of it. Then what do I do? Right? I always ask people to think differently about it. If you've vetted us, you've trusted us, you know that we're good at what we do, we have integrity about how we're going to spend your money. Don't sweat the particular new detail, right? Trust us that we are in the game for the questions that matter. That's why you came to us in the first place. That's why you were attracted to us as a funder. So trust that and go with it, and help us. We're all spoon in the ocean. We're all spoon in the ocean. And some funders get that and don't mind it. And others funders say, oh, well, I want something that's smaller and more personal. Well, okay, but I got 1,100 kids to represent.
Yeah, I hear you, Frank. Okay, so I have a question for Jake. Jake, I'm going to get you to unmute while I ask it. So somebody is curious, does any state have an exemplary system where juvenile justice and child welfare work really well together? And you and I have talked about this, and I'm curious what you'll say.
Yeah, it's always tough when you get in that sort of who's your favorite kid. I would say that there's you can pull out like a example of one thing a state does well or another thing another state does well. In my experience, what it's been is they need to dig into what's obstructing their ability to work together. I want to pick up on something Frank said earlier about who's paying for this anyway. We worked in a state where if a kid in the child welfare system picked up a delinquency charge, almost no matter how small, instantly the juvenile justice system started footing the bill. Imagine what happens in that state when there's a budget decline and the governor asks for 10% across the board cuts. All of a sudden, I have a very easy lever I can pull to totally offload my case and charge someone else money, right? These are the kind of like misaligned incentives that I think, we keep talking about the juvenile justice system or the child welfare system. Another dirty secret, I think someone mentioned dirty secrets in the field, is that there's no system. There are county government-run agencies, there are state-run government agencies, there are nonprofits who contract, there's federal requirements, there's overlapping jurisdictions. Really what it is a collection of agencies where my output is your input, and no one's in charge of any of us. And so one of the most difficult things here is bringing those people together and saying, do we want to work together as a system? Or are we going to continue in a mode of, this is my agency, this is my budget, I'm going to do the best by it? And that's where states get in a piece of trouble.
Tim, Frank, anything you want to add on that? Any examples of where you think the two systems are exceptionally working well together? Or has Jake done a good job of describing how it actually works? Tim?
I think Jake's done a great job of describing it. I don't have anything to add.
All right, and Frank?
One of the reasons it's hard to answer the question is because kind of so little time and money is invested in research. When we deliver programs, we often do it because of the next good idea or the next cool grant opportunity, right? That's how I do it. I scan the field of grant opportunities, both in the philanthropic, in the philanthropy side and the government side, right? And I get here's an opportunity that the feds post for something, and this is the certain parameters, and we get together and say, well, how could we meet this particular grant objective? Right? It's not research-based. It's very rarely research-based. And unlike what we've now witnessed in the medical field, with the testing of vaccines, for example, but what we've really seen for 30 years in medical sciences and in pharma, there's a lot of testing before stuff is introduced into the American population. That's not the case in our work. And so now we look back and we say, well, what works? And we don't have a clue. We know, as Jake said, we know about these kind of episodic models right? This group of 20 kids or 2,000 families or a county over here that did something well for a while. We ought to be more research oriented, more thoughtful about how we deliver on service and how we evaluate it. And then, of course, we ask the philanthropy side to pay for that research as well. And that's another hard get when all you're getting is a $5,000 grant, right? How do I pay for that?
So do academic centers, so this is my follow-up on this, do academic centers get involved in this kind of work? And is this the type of thing that they're
only if you pay them,
right?
Only if you pay them, right? The big schools, there's an old phrase in some circles called the vigorish. The vigorish is the fee that the loan shark charges, otherwise known as the VIG. And I call the VIG the percentage that the university, unnamed universities, will charge if you want to do a research project with them, because they have to pay their operating costs. And it's going to be like 30%, right? So if you give me $100,000 for a project and I involve a big university, I may very well have to give them 30 just to be in the game.
Okay.
On top of whatever the expense of their staff person is.
Right.
That makes it really hard. You'd love for them. There's some tremendous academic research going on in this.
Can I jump in on just to follow up on what Frank was saying?
Yeah.
Just on the research side, I'm a little more bullish. I think Frank points out that we don't have the research we want, but I don't want all the folks listening here today to go with the idea that we don't know anything. And philanthropy has played a big role in that. So I'd call out, MacArthur Foundation put some foundational money into two studies. One's called Pathways for Desistance, and the other is a whole set of series on brain science. Pathways for Desistance is the longest longitudinal study of serious delinquent offending in this country. Tim, you probably know about this because one of the study sites was Phoenix, the other, Frank, was Philly. And what they found was that out-of-home placement of juveniles after controlling for 66 variables had virtually no impact on recidivism, and longer lengths of stay don't matter. The brain science research, I think, was transformative in how people think about the ability of youth to delay gratification and think ahead and anticipate consequences. And that has really shifted how the field thinks. I think it's really helped drive reforms in a lot of cases. So that's a case where, people always wonder, is this research ever going to make any difference? Those two pieces make a lot of difference. We actually flew in, when we were working in Kansas, state I mentioned earlier, we flew the lead researcher on, the lead researcher on Pathways to Desistance to Topeka, had him brief the governor. Right? He sat there for an hour. Governor's time's valuable. He sat with the lead researcher for an hour. And I think it changes his view on this issue.
I think you're absolutely right. I do it. I'm
gonna jump in, Frank. I'm gonna jump in, Frank. So we have some other questions, but this question of research is actually an interesting one. And Jake, I kind of want to see that study, especially since it's Phoenix and Philly. So I want to come back, since we are talking about the rights of children, right? This is what initiated this conversation today. Tim, you mentioned that there is a case in the Supreme Court and we are waiting for the decision. Now, you also mentioned that Jen Justice filed an amicus brief in that case. Well, Frank and his organization are also involved in that case. So we have an opportunity to talk about the rights issue a little bit more. So Tim, let's go back to what you said. Your organization filed an amicus brief in this case because you think it's an important opportunity to establish that kids have an interest in these types of decisions, right? So remind us, what is the position that Generation Justice took?
Yeah, so this case, as it's framed in front of the U.S. Supreme Court, is largely centered around questions of religious liberty and the rights of Catholic charities and the city of Philadelphia. And as we looked at the case, we thought that there was really a voice missing, and that was the voice of the children. The children need as many potential adoptive families and the largest potential pool of adoptive families that we can afford, and that we can't have the state deciding that they're not going to partner with religious organizations simply because they don't approve of the religious organization's particular beliefs, and that we need an all hands on deck approach here. And so, that would also mean that the state couldn't say, we're not going to license LGBTQ families and allow them to be part of the adoption system. Like, no, we need them as well. We have a lot of LGBTQ kids in the system who need loving families, whether that's a religious family or not. We need to bring in as many voices, as many partnership organizations as possible. And so if you look at the rights of the kids and recognize that they are the ones whose rights and interests are really at stake here, they're the ones who need as many possible potential adoptive families as possible. As Frank mentioned earlier, that there's a real shortage these days of families who are willing to enter in the system and engage with some of these kids. Some of them have desperate needs. We got a lot of kids on adoptive waiting lists. So it was our view that if the court took the kids' rights seriously, found that they've got a liberty interest here, that the state would have to come forward and meet a really heavy burden to justify the exclusion of Catholic Charities from participating in its foster and adopt system the way that it's structured, to work with outside private organizations. So that was the position we took at Gen Justice.
Okay. And Frank, and I'm starting to get the timing reminders from the very capable group that we have behind the scenes helping us. Our events team is amazing. Thank you to Jessica and Ale today. Frank, in about a minute, what is the position that SCCA is taking on this case?
Well, we got in for the exact same reason on the other side. We too thought that the interests of the kid need to be articulated and stood for. And so we moved to intervene as a defendant, and we were accepted and approved. And so along with the city of Philadelphia, the Support Center for Child Advocates and Philadelphia Family Pride are defendants in the case. And we think too that kids need welcoming homes. They need homes that will recognize who they are. We had a particular interest in the gay and lesbian kids. And it doesn't seem to me to make any sense to tell gay and lesbian kids that they shouldn't grow up to be gay and lesbian parents. That was a kind of big hurdle logically, and from my perspective, with the position of Catholic Social Services, which was to basically say, we're not going to allow gay and lesbian foster parents to marry gay and lesbian foster parents. They didn't necessarily have that position for single people, but it was all about gay marriage became the rub. And we think symbolically kids need to be affirmed and that all families need to be valued. So we stood with Philadelphia Family Pride, which is an organization that works with gay and lesbian parents. And we're hoping you lose, Tim. No, just we're all anxiously awaiting the result. It's a very big case.
We're all pulling for the court to recognize that kids have rights and interests at stake in this litigation.
At the end of the day, that is exactly what I was going to say. At the end of the day, we may have different perspectives on what the system needs to do and how it needs to operate. But what is clear is that there are rights of children involved. And that they do need to be represented somehow, and protect those rights need to be protected constitutionally. And even amongst friends and people who are very passionate about these issues, we are going to have differences of opinion and different arguments to make. And, pursuing the truth on these and getting to the best solution in the interest of the kids is why I think you're all here. So I think we have last minute, and actually somebody put a Q&A, a question in the box that actually was my last question. So whoever that was, we were thinking the same lines. So I'm curious, really, what is the one federal law, or maybe have to make it federal. What is the one law that you would like to see changed by the end of 2022? That's my last question for you. Between now and the end of 2022, what one law would you like to see changed? And Frank, I'll start with you.
I think we have to break down the silos of Title IV-E, that we have to allow child welfare system to access funds according and be as driven by the needs of the child and family without regard to which pot of money they're coming from.
Okay. All right. Thank you. And Jake.
I'm going to stick with Frank's money theme. One of the biggest issues we see is that state and local fiscal incentives are really poorly aligned. So if I'm a county judge or probation officer and I send a kid to a state facility, it doesn't cost me a dime, but the state shells out $100,000. Alternatively, if I do a really good job and serve the kid well locally, none of the money follows the kid. So there's no benefit to me. People overeat at buffets and they overdrink at open bars, and the same problem persists in the juvenile justice and, for that matter, criminal justice system.
All right, thank you, Jake. Tim, is it the money? What do you have for us?
Well, I think Frank's right that we do need to break down the silos under Title 4E. There's absolutely no doubt. But I would have picked a slightly different law, which is that there's actually a bill in Congress right now that would require states to better categorize and track why kids are being removed for quote unquote neglect. That's a really important category. We just don't have enough data. A lot of people just assume that neglect means poverty, but it could mean a whole lot of different things. And we just don't have a good idea. But we do know that there are a lot of kids in care who are allegedly being neglected, and yet they're still dying in care. And so I think we need to do a better job of categorizing, breaking down what it means when the child welfare system is going to intervene in that child's life, and potentially take them. Is it because of a drug or substance abuse problem? Is it mental health issues? Is it poverty? Like what is going on, and really have a better idea of what's happening. And I think that particular bill would give us a lot more data. To go back to Jake's theme and Frank's discussion of data early on, give us a better picture into the window and help us design better solutions to address the problems that exist in the system.
Okay, well, we have our work cut out for us. Well, you have your work cut out for you between now and 2022. And thank you, all three of you and your organizations, for the really important work you're doing. I mean, let's not forget the numbers that we talked about at the beginning: 440,000 children in the child welfare system, 18,000 going missing a year, 48,000 juvenile justice, and then all these intersections between the two. And I'm actually wondering what to describe them as, because they clearly not quite systems, and that's one of my takeaways from our conversation today, is calling it a system is almost too organized. So thank you for sharing all the work you're doing, for giving us a sense of what has to be done going forward. And we'll be looking forward to following your work. Thanks for being with us today.